We hope everyone's having a fantastic week. It's been a crazy week here in Springfield. The legislators are all here at the Capitol, and we are representing you. Lindsay Wagahoff is over there right now, as a matter of fact, talking to the legislators about things that are happening now in veto session, and also things that are going to be happening in 2018, and we look forward to that in the future as well. We're going to continue our kind of a 3-week series, if you will, on provisions within your PPO contract. Now, just a quick snap review. Remember, we don't encourage you one way or another as to whether or not you should participate in any network. But what we want to do is just call your attention to some of the provisions that are in contracts that you may miss, that you may gloss over as you're skimming the huge amounts of paperwork that are sent to you when you're looking at joining a particular network. And so a couple of those things we're going to touch on this week. We've covered several things in the weeks past. We're going to talk about, did you know that some PPO contracts require you to maintain specific hours of operation? It may be a total number of hours that you have to be open in any given week. It could be X number of hours, meaning you have to be open during a particular time. Just watch those provisions, mainly so you're aware, so that they don't conflict with what your business model may indicate. Additionally, you want to look at, we talked about bounce billing patients last week. This week, just another reminder in there, you may want to also look and see if there are provisions in that contract that prohibit your use of collection agencies. So if you have a patient that you're unable to collect those amounts that aren't covered by the insurance, and you are able to balance bill, but if your contracts restrict your use, then you could be in violation by pursuing patients on claims. And you all know me, you've heard me say 100 times probably, involve the patient in the payment process, that you provide a good and valuable service and you deserve to be paid for it. And I do believe those, but I just want you to be aware of those provisions that may or may not be in some of your PPO contracts. Termination provisions are another one. You want to be really familiar with the termination procedures and process, and potentially delay the amount of notice that you have to give if you're looking to terminate out of a particular network. And some of those delays may correlate with their legal requirements to notify patients if you're no longer a part of their network. So those things are all kind of important to watch. So look at the termination provisions. You also want to look and see what requirements do they put on you post-termination. And so you think that, okay, I'm done with that contract, I can set it aside, I have no obligations. But if you've previously agreed to a set of obligations that actually live in perpetuity, that continue after the termination of the contract, then you just want to make sure that you're aware of those particular provisions and make sure that that you can abide by them and they fit within the confines, again, of your business model. So those are just things to be aware of. Also, you also want to look and know, are they able to sell or lease the network to other insurance companies, to other networks, to a number of different players? One of the areas that we see this happen a lot with, and especially now, is you'll have some PPO providers where you have given them authority by signing the contract that they can lease their network, which also then leases kind of your contract through them to another organization. And we see this happen in personal injury cases and work comp cases. And so you want to take a look at those provisions and at least be aware that they exist and make an informed decision, knowing that you could be giving them permission to kind of wrap the fee schedule and the requirements and that they have for you as a contracted provider into PI cases and work comp cases. You want to make sure that you're aware of those. Also know that all of these provisions that we've talked with, they're able to be negotiated. Now, what do I mean by that? Well, let's be quite candid. There's a lot of the organizations that aren't going to negotiate any of these provisions. There's some that only may negotiate a few of these provisions, but it's enough hit and miss. And the reviews that we get back from our doctors when we encourage them, if they have a trouble with a particular provision, we encourage them, attempt to negotiate. That is, you're right. You can always attempt. And then if they say no, then you can make that informed decision at that stage, or they may make modifications for you. And so again, we're not encouraging anything specifically, but just giving you your rights, if you will. You always have the right to attempt to negotiate a contract. Nobody's holding a gun to your head per se, but in a sense, you want to make sure that you've exercised all of your rights and you know exactly what your rights are. So in these cases, you're able to negotiate. You can try. They can always say no. You can disagree with them. You can go through the embattlement, but at the end of the day, at least you're familiar with the provisions that are in the contract. Again, in week one, we talked about this, and it may seem elementary, but I can't strongly urge you enough to make sure that you have read through the contract before you sign it, that you have access to the fee schedule, and you have a full understanding of exactly what you're signing before you get involved with any contract. We hope this helps you out, and we'll see you next week. Take care.